Welcome, and thank you for joining us. Please note that this AI-generated podcast is intended solely for general learning and educational purposes. While we strive to ensure accuracy, the AI may occasionally produce errors or incomplete information. We strongly encourage you to consult qualified professionals and conduct your own due diligence before making any legal, financial, or business decisions based on the content presented here. Also, if you find this content valuable, we kindly request you to like the video, subscribe to the channel, and activate the notification bell to receive updates on future episodes. Let's begin.
Have you ever looked at a brilliant new gadget and thought, wow, that's clever, but it seems so obvious now? Innovation often means building on existing ideas, doesn't it?
It really does.
But here's the big question. When is an invention truly groundbreaking, something deserving patent protection? And when is it just, the logical next step, an obvious evolution?
That's the million-dollar question in patent law sometimes.
Today, we're diving deep into a really important Supreme Court case that fundamentally reshaped how we define obviousness in patent law. We'll unpack a fascinating legal battle. It involves car pedals, electronic sensors, and what it really means to invent something. Our mission for you, listening in, is to understand not just the outcome, but the really crucial legal shift this case represents for innovation.
Exactly. And the core concept here is patent obviousness. Basically, you can't get a patent if your invention would have been obvious to someone with ordinary skill in that field at the time you invented it.
Sounds simple enough.
It sounds simple, but applying it, that's where it gets tricky. And like you said, it leads to a lot of disputes.
Okay, let's unpack this specific case then. We're talking about KSR International v. Teleflex Inc. et al.
That's the one.
So let's get the basics down first. The case number is 040-350. It's a United States Supreme Court decision handed down April 30th, 2007.
And it was unanimous. Justice Kennedy wrote the opinion for the whole court.
Right, unanimous. The petitioner was KSR International Co.
And the respondents were Teleflex Inc. And its subsidiary technology holding company. We can just call them Teleflex.
Okay, Teleflex. So essentially, Teleflex owned a patent. KSR was accused of infringing it.
And KSR fought back, saying the patent shouldn't have been granted in the first place because the invention was obvious.
Got it. So the Supreme Court had to settle whether that patent was valid. Now, to really get this, we need a little background on the tech, right? Car pedals.
Yeah, a quick bit of engineering history. For a long time, accelerator pedals were just simple mechanical links to the engine. Fixed position. You adjusted your seat, not the pedal.
Right, I remember those.
Then, around the 70s, adjustable pedals started appearing. People wanted pedals that could move closer or further away.
Makes sense for different driver heights.
Exactly. And there were different designs. One key early one was the Asano patent. It had this clever design where the pedal moved, but one of its pivot points stayed fixed. This gave a consistent feel.
Okay, fixed pivot point. Important detail.
Very important, as we'll see. There were other designs, too, like the Redding patent, where pretty much the whole pedal assembly shifted.
Then cars went electronic.
Right. Computer-controlled throttles became the norm. No more cables, just wires sending signals. This created a brand new need, an electronic sensor to read the pedal position and tell the computer what to do.
And inventions followed.
Naturally. You had patents like the 936 patent, showing how to put the sensor in the pedal mechanism itself. Then, crucially, the Smith patent taught that putting the sensor on a fixed part of the whole assembly was better. It stopped wires getting chafed or damaged.
Solving a known problem.
A known problem, highlighted by things like the Rixson patent, which had the sensor in the footpad and apparently suffered from that exact wire chafing issue. And you also had modular, sort of off-the-shelf sensors popping up, like in the 068 patent. These could be easily added to existing pedals. Chevy trucks were already using sensors like this, attached to the support bracket.
Okay, so the pieces are starting to come together. Adjustable pedals, some with fixed pivots like Asano, electronic sensors, ways to mount them on fixed points to avoid damage. All known concepts.
Exactly, all floating around in the industry.
So how did KSR and Teleflex fit into this picture?
Well, KSR already had an adjustable pedal product, the 986 patent product, but it was for the old cable-style throttles. When GM came asking for adjustable pedals for their new computer-controlled trucks,
Let me guess. KSR just added a sensor.
pretty much, they took their existing adjustable pedal design and added a standard modular electronic sensor to it. Seemed like a logical modification.
And Teleflex.
Teleflex held the license for a patent by Stephen Engelgau, the Engelgau patent. The key part for us is Claim 4. It described an adjustable pedal assembly where the electronic sensor was specifically attached to a fixed pivot point on the support structure.
Just like Asano's fixed pivot point concept.
Very similar idea, yes.
Mm-hmm.
The sensor stays put while the pedal moves. But here's a really critical point. The Asano patent, with its fixed pivot, was apparently never shown to the Patent Office examiner when Engelgau was applying for his patent.
Oh, interesting. So the examiner didn't know about Asano.
Seems not. The PTO actually rejected an earlier, broader claim from Engelgau because it looked obvious when combining Redding's pedal with Smith's fixed sensor idea. But Claim 4, with that specific limitation about the fixed pivot point, got through. Without Asano on the table, it looked more inventive than perhaps it was.
So the fight begins. Teleflex sees KSR's design for GM.
Yep, and sends a warning letter. You're infringing our Engelgau patent, Claim 4.
And KSR says,
Essentially, no, we're not paying royalties because your Claim 4 is invalid. It was obvious. And that led Teleflex to sue KSR for patent infringement.
okay, so it lands in court. What happened initially?
The first round went to KSR. The district court agreed with them and granted summary judgment. That means they decided the case right then without a full trial, finding it clear that Claim 4 was obvious.
Why? What was their reasoning?
They basically said there wasn't much difference between the prior art, like combining the ideas in Asano and Smith, and what Engelgau claimed. They looked at the Federal Circuit's own test at the time, the teaching, suggestion, or motivation, or TSM test, and found enough motivation in the industry and existing patents like Rickson and Smith to combine an adjustable pedal like Asano's with a fixed sensor.
But it didn't end there.
Nope. Teleflex appealed to the Federal Circuit, which is a specialized appeals court for patent cases, and the Federal Circuit reversed the district court.
Reversed? Why?
They said the district court hadn't applied that TSM test strictly enough. They argued that the prior art patents, like Asano or Smith, weren't trying to solve the exact same problem Engelgau was focused on. And crucially, they dismissed the idea that something being obvious to try could make it legally obvious under patent law.
So a much more rigid view from the Federal Circuit.
Very rigid. And that rigidity, that strict application of the TSM test, is what set the stage for the appeal to the U.S. Supreme Court.
Right. So this is where it really gets to the heart of the matter. What was the core legal question the Supreme Court needed to answer in KSR v. Teleflex?
The absolute main issue was how to interpret and apply the obviousness standard under the Patent Act, specifically 35 U.S.C. Section 103. Was the Federal Circuit's very structured, very rigid teaching, suggestion, or motivation test the right way to do it? Was it consistent with what the Supreme Court had said in the past about obviousness?
So the TSM test itself was kind of on trial.
In a way, yes. And tied to that was the question of whether summary judgment deciding the case early without a full trial was okay here.
Okay. So Teleflex is defending its patent in front of the Supreme Court. What were their key arguments? How did they try to convince the justices that Claim 4 was truly inventive, not obvious?
Well, first, they maintained KSR's pedal clearly infringed Claim 4. But on the obviousness point, they argued it wasn't obvious. They hinted that Asano's design was actually maybe too clunky or complex to easily combine with a sensor in the way Claim 4 described.
Trying to distinguish it from the prior art?
Exactly. They also leaned on expert testimony calling Claim 4 a simple, elegant, and novel combination, especially compared to the known issues with the Rickson patent sensor placement. And they tried to bring in secondary considerations, things like the commercial success of their product, as evidence that it must have been non-obvious, although the district court hadn't bought that argument earlier.
And KSR's response, how did they push back against Teleflex and the Federal Circuit's ruling?
KSR stuck to their guns. Claim 4 was invalid because it was obvious. Their argument was pretty straightforward. Look, taking an existing adjustable pedal that already has a fixed pivot point, like Asano's, and adding a known type of modular sensor to it, that's something an ordinary engineer would think of. The benefit, a stable sensor position, was completely predictable.
Makes intuitive sense.
And their main legal attack was on the Federal Circuit's TSM test. They argued it was way too rigid, too formalistic, and completely inconsistent with the broader, more flexible approach to obviousness the Supreme Court had laid out in earlier landmark cases.
So the stage is set, arguments made. What did the Supreme Court decide?
The Supreme Court came down decisively. They unanimously reversed the Federal Circuit.
Unanimously?
Yes. They stated very clearly that the Federal Circuit had applied the obviousness standard in a narrow, rigid manner that just didn't align with the law or with Supreme Court precedent. The bottom line, Claim 4 of the Engelgau patent was obvious and therefore invalid.
KSR wins. But why? What was the court's reasoning? This is where the big shift happens, right?
Absolutely. This is where they really clarified things. First and foremost, they slammed the brakes on the rigid TSM test. They went back to foundational cases like Graham v. John Deere and said those cases established an expansive and flexible approach, not a rigid and mandatory formula like the TSM test had become in the Federal Circuit's hands.
So TSM wasn't wrong, just applied too strictly.
Kind of. They said the TSM test could offer helpful insight, but it shouldn't confine the obviousness analysis. They stressed that real-world factors like market demand or solving a known problem often provide the motivation to combine existing ideas. Patenting every predictable combination, they warned, actually retards progress.
Okay, so loosen the TSM test. What else did they point out as flaws in the Federal Circuit's thinking?
Several key things. One, the Federal Circuit was wrong to focus only on the specific problem the patent inventor said they were solving. The Supreme Court clarified that any need or problem known in the field could provide a reason to combine elements. The real question is, what would have been obvious to a person of ordinary skill in the art, not just what the inventor was thinking?
Broader perspective.
Much broader. Two, they emphasized common sense. The Federal Circuit acted like engineers only look at prior art designed for the exact same purpose. The Supreme Court said, basically, come on. Familiar things often have obvious uses beyond their main purpose. Skilled people fit the teachings of multiple patents together like pieces of a puzzle.
So even if Asano's main point was constant ratio, its fixed pivot was still relevant.
Precisely. It clearly showed an adjustable pedal with a fixed pivot, and other patents, like Smith, already suggested a fixed point was the best place for a sensor to avoid wire chafing, a known issue from Rickson.
It all seems to connect logically.
It does. And three, a really big one. Obvious to try. The Federal Circuit had dismissed this idea. The Supreme Court said, hold on, if there's a known problem or market pressure and only a finite number of identified predictable solutions, then trying those obvious solutions is likely just ordinary skill and common sense, not true invention. So, obvious to try can indicate obviousness in those situations.
That's a major clarification.
Huge. They also cautioned against being too scared of hindsight bias. While it's a real concern, they said creating rigid preventative rules that deny fact-finders recourse to common sense isn't the answer.
Okay, so applying this more flexible common sense standard to Engelgau's claim 4.
Applying that, the Supreme Court agreed entirely with the original district court. Combining the Asano pedal concept, adjustable fixed pivot, with a known type of sensor mounted on that pivot point was obvious. Why?
Yeah.
Strong market demand for electronic pedals. Start with Asano. Where do you put the sensor? Smith says put it on a fixed part to avoid Rickson's chafing problem. The most obvious fixed part on Asano, the pivot point.
Seems clear when laid out like that.
They rejected Teleflex's argument that Asano taught away from this combination, finding no real evidence Asano was too flawed to be adapted, especially when similar pedals were being adapted. And those secondary factors like commercial success, not nearly enough to overcome the strong evidence of obviousness.
And what about the summary judgment issue, deciding without a full trial?
The court said summary judgment was appropriate here. Obviousness, they reiterated, is ultimately a question of law for the judge to decide based on underlying factual findings. When those facts, the prior art, the claim, the skill level, aren't genuinely disputed and the conclusion of obviousness is apparent, the court can make the call, even if one side presents expert testimony saying otherwise. Conclusory opinions don't override clear facts.
That's a very thorough reasoning. What specific laws or previous cases formed the bedrock of this decision? You mentioned Graham v. John Deere.
Right. The absolute cornerstone is 35 U.S.C. Section 103, the part of the Patent Act requiring non-obviousness. The framework for applying Section 103 comes directly from Graham v. John Deere Co. of Kansas City from 1966. That's the seminal case outlining the factual inquiries needed. They also look back further to foundational ideas from Hotchkiss v. Greenwood, 1851.
And cases about combining old ideas.
Yes, they cited cases like Great Atlantic and Pacific TCO v. Supermarket Equipment Corp., 1950, which warned against patenting simple combinations of old parts doing their old jobs. Also, United States v. Adams, 1966, which noted combinations need to do more than expected, but also that prior art teaching away can support non-obviousness, so it didn't help Teleflex here. And cases like Anderson's BlackRock and Secreta, reinforcing that combining known elements for predictable results is generally obvious.
So a solid foundation and precedent, and you mentioned it was unanimous, no dissenting opinions, no separate concurring thoughts?
That's correct. Justice Kennedy delivered the opinion for a completely unified court. No dissents, no concurrences. Everyone was on board with this clarification.
That unanimity really underscores the significance. So let's connect the dots. What is the lasting impact? Why should we, whether we're inventors, business folks, lawyers, or just curious, care about KSRV Teleflex today?
Well, connecting it to the bigger picture, its impact is huge. First, it brought flexibility and common sense back into the obviousness analysis. It decisively moved away from the Federal Circuit's rigid TSM test, demanding that broader context, market realities, and ordinary creativity be considered. This generally made it somewhat easier to challenge patents, particularly those based on combining known elements.
So potentially fewer patents granted for simpler combinations.
Potentially, yes. It reinforced the idea that predictable combinations are likely obvious. If the market needs something and the solution involves putting known pieces A and B together in a way that achieves an expected result, that's probably not inventive enough for a patent. The court wanted to stop patents from stifling the natural flow of incremental innovation.
And the obvious to try point.
That was critical. It legitimized obvious to try as a factor in the analysis, particularly when dealing with a limited number of predictable paths to solve a problem. It recognized that sometimes the invention is less a flash of genius and more methodical exploration of known options.
What about the legal process itself?
It also clarified the role of summary judgment, empowering courts to decide obviousness as a matter of law more readily when the underlying facts are clear, potentially making patent litigation a bit more efficient in certain cases.
And the overall effect on innovation.
The overall effect, arguably, is to raise the bar slightly for inventiveness, especially for inventions that are primarily combinations of existing technologies. It pushes inventors towards more significant breakthroughs rather than just assembling known parts, aiming to ensure patents reward genuine leaps forward.
Okay, if you had to boil this whole deep dive down, all this complexity into one single most important takeaway for someone listening, what would it be?
One key takeaway. I think this raises an important point. The most crucial lesson from KSR v. Teleflex is that patent law is designed to reward true innovation, not just skillful engineering or the obvious next step. The Supreme Court put common sense, market context, and predictability front and center in the obviousness test. It's a reminder that the goal is to promote the progress of science and useful arts, not to grant monopolies on every minor adjustment or predictable combination of things we already know.
So the next time you encounter a new invention, maybe ask yourself, is this genuinely surprising? Or is it more like putting known Lego bricks together in a way lots of people might have thought of? It's not just about being new, it has to be non-obvious.
Exactly. It pushes us to really consider what makes something truly inventive versus just a competent application of existing knowledge. It's a vital distinction if we want to keep real innovation moving forward.
Well, thank you for guiding us through the complexities of KSRV Teleflex. Hopefully for you listening, this makes the whole idea of patent obviousness a bit clearer and shows why this case was such a landmark. Keep asking those big questions about innovation. That's how we learn.